SMS Zaqy Mohamad.
Mr. Speaker, sir, on behalf of the Minister of Manpower, let me thank all 13 members who have spoken in support of the bill. Professor Fatima Latif had asked about the trend in number of WICA claims and how our safety performance stands among our peers. In line with Singapore's improving WISH performance, the number of awarded claims has fallen by 7% in the past 3 years, from around 15,700 in 2015 to around 14,600 in 2018. As the WICA is but one option for employees to seek compensation for work injuries, a better reflection of our workplace safety is the workplace fatality rate. As mentioned in my earlier speech, our 3-year average fatality rate has improved significantly from 18th place among OECD countries in 2010 to 7th place in 2018. We are working hard towards the goal of having a rate of less than 1.0 per 100,000 workers by 2028, which will make our workplaces one of the safest in the world. Mr. Douglas Foo and Ms. Jessica Tan asked about how MOM will share policy and claim information with insurers. Only authorized representatives of designated WIC insurers will be allowed to check on employers' information. As mentioned in my earlier speech, the Ministry will not be revealing the actual workforce size and annual payroll data to insurers. Rather, our system will just tell insurers that their client's declaration is either consistent or not consistent with MOM records. Ms. Jessica Tan also asked about transparency in premiums quoted by insurers. The WIC insurance market today is highly competitive, with 31 insurers operating. As in other insurance products such as motor insurance, employers can approach different insurers to obtain a quote based on their company activities, accident record, and workforce size. MOM will also explore, to take on board Ms. Jessica Tan's suggestion, how best to publish general information on the range of premiums quoted to help employers see where they stand and to encourage them to strive for a clean safety record to obtain the lowest premiums. I would like to thank Professor Latif for highlighting the need for expeditious claims process. Now, this is core to WICA. The average time for claims for permanent incapacity or death to be resolved is 4.5 months after the claim has been filed. Amendments such as streamlining of the claims process and compensating based on current capacity will further shorten the claims process. With regards to insurer processing claims, Mr. Patrick Tay, Ms. Anthea Ong, Associate Professor Walter Tezera, Mr. Zainal Sapari, and Mr. Melvin Yong have asked about measures that are put in place to safeguard employees' interests. As I have detailed out in my earlier speech, the interests of the employees will continue to be protected as insurers do not have discretion in setting the compensation amount. Just to lay your fears against, insurers do not have discretion in setting the compensation amount. Compensation for incapacity is based on the assessment of a health professional and computed using a fixed formula based on age and earnings. And the Ministry will put in place a system of check and balances in the licensing scheme to ensure that claims are processed fairly and in a timely manner. Employees who feel that their compensation was not processed fairly can raise objections to us, which will continue to be adjudicated by the Ministry. Employees who face other problems or suspect errant behavior by insurers or employers should report this to the Ministry. Nevertheless, given that this is a new regime, I fully agree with member Mr. Zainal Sapari that we should conduct reviews at appropriate junctures to fine-tune if necessary. Mr. Zainal Sapari sought clarifications on whether employees who are compensated based on their CI assessment are able to seek reassessment if their injuries deteriorate further. Firstly, I want to say that a doctor will not make a CI assessment unless he is of the view that there is unlikely to be a significant change in the employee's condition. Secondly, in coming up with a CI framework, we consulted with the WIC Medical Board, which comprises medical professionals that help MOM to review appeals against the treating doctor's assessment of incapacity. The medical board confirmed that the state of incapacity 6 months after the accidents would be very close to the eventual extent of permanent incapacity in the vast majority of cases. So thirdly, in an unlikely event that the employee's condition deteriorates significantly after the CI assessment, the new WICA provides for the initial assessment to be revised if the doctor can provide the reasons for the revision within 90 days after the deadline to raise objections. Mr. Louis Ng sought clarifications on whether the introduction of current incapacity will affect the employee's WICA entitlement to medical treatment for their work injuries. Under the new WICA, employers are responsible for the employee's medical expenses up to $45,000, or 1 year from the accident, whichever is reached first. This entitlement is independent of the medical assessment of either the PI or the CI. So it's independent, you will still get it, right? As mentioned in my earlier speech, CI assessment would take place at least 6 months after the date of accident, where the WIC Medical Board assesses that the extent of incapacity is a close approximation of the steady state incapacity for most cases. So as such, the bulk of the medical treatment and hence expenses would have taken place before the CI assessment. So the introduction of CI assessment therefore allows foreign workers to recuperate and be with their loved ones earlier in their home countries. And I know that this view is echoed by Mr. Zana Sapari, who is familiar with the worker situation through the unions and the MWC. I would also like to thank Mr. Louis Ng and Professor Fatima Latif for highlighting the importance of employers to provide itemized payslips and difficulties that we face when such reliable documentary evidence is unavailable. So it is mandatory under the Employment Act for employers to issue itemized payslips to the employees. It's an offence not to do so. So to address the handful of cases that we see each year that lacks reliable documentary evidence to determine AME, the Commissioner can either set the derived AME based on the co-worker's earnings or a multiple of the employee's basic rate of pay. So for the latter, the multiple will be set at a level such that the derived AME is higher than industry norms, further incentivizing employers to provide proper documentary evidence. That is, the employer is likely to be worse off if he does not provide documentary evidence or payslips, itemized payslips. So Mr. Patrick Tay, Mr. Arasu Duraisamy, and Professor Fatima Latif proposed higher coverage for compulsory insurance and a faster pace of implementation. The Ministry had originally proposed during the public consultation to raise the salary cap in one step. However, employers were concerned about the cost pressures they were already facing and an uncertain economic outlook. So the eventual outcome of a two-step increase was a tripartite consensus. I would like to place on record my appreciation for our union leaders, and I'm sure employers also feel likewise. MOM will continue to consult tripartite partners on the time frame for compulsory insurance to be adjusted further. I note Mr. Patrick Tay and Ms. Jessica Tan were concerned employers may insure under WIC. As part of the licensing conditions, designated insurers will have to report to the Ministry their data on the number of workers insured by each of their clients. This will be checked against our own records of companies' workforce size to identify which companies are not insured or which companies are underinsured. Professor Fatima Latif asked about dental claims. I'm happy to confirm that under the new WICA, employees can claim for medical fees incurred for dental procedures from any registered dentist in Singapore if the need for dental procedure arose out of a workplace accident. Mr. Douglas Foo sought clarifications about compensation for light duties. Employees who are on light duty but are absent without reasonable excuse or leave will be ineligible for such compensation. Mr. Patrick Tay suggested to compensate injured employees with light duties with the full AME for the full period of light duties. With the new WICA, we have made the treatment of light duties to be on par as medical leave. So just as full AME is payable for the 14 days of medical leave under the existing WICA, full AME is also payable for the first 14 days of light duty or medical leave. The WICA adopts the sensible approach of compensating the full AME for the first 14 days of medical leave and 60 days of hospitalization leave. For injuries that require more than the combined 74 days of medical and hospitalization leave, AME is not fully compensated because such injuries would be serious enough to warrant an award for PI. Mr. Louis Ng, Dr. Chia Shi Lu, and Professor Fatimah Latif asked for greater clarity on medical leave and light duties. With the move to expand compensation to work-related light duties and to report any instance of light duties or MCs, light duties will be treated like MC under the new WICA. So the distinction between medical leave and light duties will be less important under the new WICA. Nonetheless, I agree with the MPs that we can do more to reduce confusion on the ground, so we will work with the medical community and seek their professional opinion on the grounds for doctors to prescribe either medical leave or light duties. On Mr. Louis Ng's and Mr. Pritam's comments or questions on doctor switching, as mentioned in my earlier speech, we want to ensure that there is proper and fair assessment of the employee's injury. Therefore, in most cases, the first treating doctor will be in the best position to assess incapacity, as they have the most complete picture of the accident. However, if there are prima facie evidence of inadequate care, such as significantly shorter MC duration than from other doctors, the employee will be allowed to switch to another doctor of his choice without having to seek the employer's consent. Just have to inform MOM. The employer pays for both assessments, to Mr. Pritam's question. Mr. Douglas Foo raised concerns about the administrative work and compliance costs of reporting accidents resulting in any instance of medical leave or light duties. To ease the administrative burden on employers, the report form for those with medical leave or light duties, that there are 3 days or less, let me repeat that. The report form for those with medical leave or light duties that are 3 days or less will be simplified and shortened. Nevertheless, employers will still need to provide the additional details should the employee get subsequent medical leave or light duty that exceeds the 3-day threshold. Mr. Louis Ng, Mr. Patrick Tay, and Ms. Entia Ong sought clarifications on whether employees will be kept informed of the claims process, such as being notified when the employers report the accidents, and if they will be given the opportunity to challenge the details stated in the accident reports. Once an employer submits an accident report to the ministry, the employee would receive a letter informing that an accident report has been made, his or her rights, and the steps to be taken to receive compensation. So the ministry or the insurer will verify important information, such as injury sites and salary information with them, and conduct fact-finding if there are any disputes. To Mr. Tay's points that claimants should be kept in the loop of the WIC process, this is already the case today. Claimants or anyone assisting them can obtain information about the claim status through our websites or text messages. For the latter, they come in 4 languages, and claimants can subscribe to our text messaging service to receive notifications when the claim's status change. Mr. Louis Ng and Ms. Entia Ong also asked how the ministry intends to ensure that foreign employees receive notification of the accident reports and whether employees can obtain a copy of the accident reports for free. We will explore how we can provide such notifications. In the meantime, employees who did not receive such a letter within 3 weeks of informing the employers of their work injuries can approach the ministry for assistance. I'd like to clarify that the content of accident reports will not affect employees' amount of compensation under the WICA, so workers would not need the actual reports. Reports could be useful if the employee makes a common law claim, as it may suggest whether any party was at fault in the accident. In such a situation, it is reasonable for employees to pay the nominal fee of $5 for the report. Various suggestions were raised by Mr. Patrick Tay, Mr. Louis Ng, and Mr. Chia Shi Lu to address the underreporting of work injuries by employers. On auditing employers' reporting of accidents by referencing third-party data, this will be possible under the new WICA, as insurers will share with MOM the claims made by employers. on subjecting both employers and doctors to a duty to report work accidents, and the primary responsibility rests with employers, as they are required to ensure the safety and health of their employees. Instead of burdening doctors with additional legal liability, WICA simplifies the reporting regime for employers. As long as an MC of any sort is issued, the employer has to file a report. It also makes cases of medical malpractice more clear-cut, as it would be very unusual that any significant injury would not warrant at least an MC or light duties. So this approach allows employers and doctors to focus on what they do best, rather than making a doctor also responsible for what an employer should be doing. On the suggestion to allow employees to report to MOM, I would like to clarify that employees can already report accidents to MOM. They can do so when accidents occur or when they did not receive notice of their employer's reports. Mr. Pritam Singh raised various issues. Let me first say I first welcome his newfound interest in work injury compensation, as the Workers' Party has not so far raised any questions concerning compensation of employees for work injury during this term of Parliament, but it would have also been nice to have heard from the WP when we had the public consultation for WICA, but it's never too late to start. So Mr. Pritam shared the case of R and asked if there were gaps that led to the late reporting of this case. We have managed to trace the case he referred to, and fuller facts would be useful for members of the House to understand the context. In R's case, he was injured in 2015 while he was on his way to training at a third-party venue. Both he and his employer did not report the injury then, as they thought it occurred when he was not at work. His employer nevertheless paid more than $54,000 for his medical expenses, which exceeded even the upcoming WICA limit on medical expenses, even though they thought it was not a work injury. R only filed a report 2 years after the accident. This was after he had left his employer, having served till age 67. Well, actually, his employer was also progressive in re-employing him up to 67, even though the re-employment obligations under the Retirement Age and Re-employment Act were up to 65 in his case. He later explained to MOM that it was only after he left employment and he told a friend, and that his friend asked him why he did not file a WIC claim. So I'd like to point out that this is not so much a case of power imbalance that the employer exploited, but in fact the employer's actions in covering the cost of medical treatment shows that the employer was doing right by the worker. MOM did not admit the claim initially, as it was not made within 1 year from the date of the accident. Upon appeal, MOM investigated further the circumstances leading to the non-reporting in 2015. It was clear from the workers' and employers' account that both parties believed that it was not a work accident. MOM therefore exercised discretion under the law to admit the claim. I should highlight that the concept of a time bar for claims exists in both WICA and under common law. When a time-barred report is filed, without further information of the background, the right thing to do is to reject it. However, there is an avenue for the claimant to appeal and provide the facts to support his appeal, as he did in this case. So in the end, as MOM admitted the claim, R was ultimately assessed to have suffered 25% permanent incapacity and awarded another $54,500 in compensation. I should also note that the employer could have taken the position that since the worker wanted to pursue a WICA claim, benefits and cover that were provided for him back in 2015, which had exceeded WICA limits for medical costs, could have been recouped. However, the employer did not do so. So far from illustrating the deficiencies in the WICA system, R's case shows how the WICA regime is robust in compensating deserving cases. Time-barred cases are reviewed if the appellant is able to provide the facts to show why a claim could not be filed earlier. It also shows that their employers are also willing to go well and above what the law mandates because they care for their workers. So Mr. Pritam also extrapolates from R's case to claim that private settlements are not fair to workers and that MOM should oversee such settlements. R's case in fact shows the opposite. The employer has actually ended up paying more than what he needs to. So while Mr. Pritam calls for MOM to put ourselves in the shoes of the worker, as our response for the case of R shows, MOM puts itself in the shoes of both the worker and the employer. So Mr. Patrick Tay, Mr. Pritam Singh, Ms. Entia Ong, Mr. Douglas Foo, and Mr. Zainal Sapari spoke on educating employees and employers on the WICA. We agree that this is important for workers to know their rights and for employers to understand what counts as an injury. Over the years, the ministry has expanded its outreach to educate employees, such as through the Foreign Workers Settling In program, and Mr. Tay has also shared the assistance and support that unions and the Migrant Workers Centre can provide to those with work injury compensation claims. So for employers, MOM will continue to conduct briefings to clarify any doubts. So MOM will continue to raise public awareness of WICA and seek new channels and partners to work with us. On the frequency of reviewing the compensation limit, I would like to clarify with Mr. Pritam saying that we have initiated reviews every 3 years. At the conclusion of the review, we announced the revised limit to take effect the following year. So the next review is then initiated 3 years later. So in the review, we consider wage growth and inflation since the last revision of the compensation limit and discuss with tripartite partners on what the new limit should be, taking into account the interests of workers as well as businesses. On Member Fatima Latif's question on age multiplying factor, the age multiplying factors are derived by taking into consideration the net present value of the worker's projected loss of earnings due to work injury until retirement age. Therefore, younger workers have higher AMFs than older workers. A few members, Mr. Patrick Tay, Mr. Louis Ng, Ms. Entia Ong, Dr. Chia Shilu, and Professor Fatima Latif, have raised concerns about workers' treatment being delayed or workers not following up on treatment because employers did not provide the hospitals with the letter of guarantee or LOG. Hospitals today ask for LOGs to be assured that employers will pay for medical expenses, since some treatments may not be for work injuries or may not be discretionary. Otherwise, the burden of bad debts could be passed on as higher costs to all other patients. Nonetheless, no worker would be deprived of treatment for work injury regardless of the ability to pay or whether an LOG was provided. Employers are already required under WICA to pay for the employee's medical treatment for any work injuries. This includes for diagnostic work like MRI scans to assess the extent of injuries. Workers should report to MOM if the employers are not willing to furnish an LOG for work injuries. We will take action against employers who fail to meet their obligation to pay for medical expenses under the Act. So in addition, the new WICA will allow the ministry to order insurers to pay medical expenses directly to the healthcare institutions if necessary. On the suggestion of insurance cards to employees to facilitate prompt treatment, I thank members for the suggestion, but would point out that WIC insurance is just one of several medical insurance products for both local and foreign workers. So local workers have their own MediShield life policies as well as company provided for insurance. For foreign workers, it's a condition of the work pass that the employer has to purchase insurance to cover medical treatment generally. So issuing cards to workers will not solve the problem of whether the medical treatment is being claimed under the correct policy, and it may even lead to greater confusion given the many insurance that's out there or that they are being covered under. So Mr. Louis Ng and Mr. Zainal Sapari inquired about the food and housing arrangements for injured foreign workers. Employers are still responsible to look after their workers while they are in Singapore, even after they have cancelled their work permits. They have to provide acceptable housing and adequate food, that is 3 meals a day, for workers whose injury claims are still pending. Before 1st August 2019, if the worker does not want to stay at an accommodation provided by the employer and requests to stay at other accommodations, we have permitted it. However, this has caused other problems such as no control over the housing conditions where workers stayed. So from August 2019, we have established higher standards for injured workers' housing. Employers have to continue housing the workers at their dorms or pay for housing and upkeep in other MOM-approved dorms. So you're going to be put in one of our approved dorms at the minimum. Ms. Anthea Ong suggested for WICA and salary claims to be conducted in parallel. This is already the case, as both claims will be processed concurrently. In the event that AME is disputed, the salary claim will need to be settled first in order to establish the correct AME. Mr. Araisu Doraisamy, Professor Fatima Latif, and Mr. Melvin Yong have asked about the coverage of mental illness and the WICA. The WICA stipulates compensation for injury by accident arising out of and in the course of work. Employees can thus be compensated for mental disorders and any resulting incapacity, even if there is no physical injury, if the following 3 criteria are met. First, the injury is a clinically diagnosed mental disorder. Second, the mental disorder is caused by an accident. Third, the accident arose out of and in the course of work. In the past 5 years, 3 cases of psychological injury arising from work-related accidents were compensated under WICA. They involve conditions such as post-traumatic stress disorder or PTSD, diagnosed and assessed by psychiatrists. WICA will cover, Mr. Araisu Doraisamy will ask whether WICA will cover work injuries sustained while telecommuting, and the answer is yes. In cases where it is clear that the injury was clearly due to work, such as the employer requiring the worker to respond urgently to work calls while at home, and the worker fell while rushing to answer the call at home, the injured worker will be entitled to WICA compensation. Mr. Zainal Sapari asked about compensation for occupational diseases or ODs with latency periods that exceed the prescribed limitations for WICA compensation. To clarify, the limitation periods for compensation for ODs are set between 1 and 3 years after the end of employment. There are indeed some ODs, such as asbestosis, with a very long latency that can be more than 10, 20 years, and employees may not be eligible for WICA compensation if they have already left the companies. However, it is not practical to impose unlimited liability to employers, right? Because they may not be in business for so long, and secondly, WICA is a no-fault regime. So therefore, the ministry has opted for a pragmatic approach by providing payouts from the workers' fund to employees with long latency ODs who are time-barred from WICA. They can also seek recourse under common law. Mr. Araisu Doraisamy, Mr. Chen Shomao, and Member Walter Tezera asked about the recourse available to self-employed persons or SEPs in the event of work injury. As members may be aware, the WICA does not cover SEPs as they are not considered employees. The service buyers of SEPs often do not have control over the SEP's work conditions and hours relative to employers' arrangements with their employees, and unlike employees where there is a clear one-to-one relationship with the employer, many SEPs also contract with multiple service buyers. So it would not be fair for multiple service buyers to compensate or purchase insurance for each SEP they contract with. So it's difficult to tell at which point in time you're working for which. So to protect themselves, the ministry has encouraged SEPs to buy prolonged medical leave insurance or PML insurance and personal accident insurance or PAI to mitigate the income loss and cost of medical treatment in the event of a work injury. SEPs can also consider seeking damages from third parties from the common law, under common law, sorry. But many SEP occupations also do not face significant injury risk, such as real estate and property agents. Different SEPs also devote different amounts of their time to self-employment. Thus, we recognize that it may be too onerous to mandate insurance for all SEPs. Nonetheless, I agree with Member Walter Tezera that the market platforms have a role to play too, given that they employ a large number of SEPs outside of traditional SEPs. And to date, at least 28,000 Grab and Gojek drivers are already covered by PML insurance, And ComfortDelGro Taxi also has plans to cover their drivers. For food delivery, the Workplace Safety and Health Council has engaged the main delivery companies to voluntarily provide personal insurance for SEP riders if they contract with, personal accident insurance or PAIs. So Deliveroo and Grab are now providing PAI coverage for their SEP riders. So I think these are some developments, and I hope that we can encourage more. Mr. Patrick Tay suggested to channel a portion of WIC claims, weekly insurance premiums, to the Workers' Fund to ensure its sustainability. The Workers' Fund provides a safety net for employees who did not receive their full entitlement of WICA benefits. And the reasons include employers who were uninsured and were in financial difficulties. At the moment, the Workers' Fund has sufficient resources to compensate cases that meet its criteria. Finally, I note Mr. Douglas Fu's and Ms. Jessica Tan's concerns about the increase in business costs due to the slew of changes in WICA. There are 3 changes that will impact business costs. 1, higher compensation limits for medical expenses, death, and permanent or current total incapacity. The nominal value of compensation is reviewed every 3 years to keep pace with wage growth and inflation. 2, wider coverage of compulsory insurance. Companies that have not already purchased WIC insurance for such workers will have to do so. But the vast majority of companies insure all their employees already. We estimate that only about 25,000 to 30,000 employees that will need to be additionally covered. Therefore, companies will not face significantly higher premium costs as a result of this change. Thirdly, the WIC insurance market is competitive, so it will be difficult for any insurer to unilaterally raise premiums sustainably. In fact, average premiums paid per employee insured declined 12% from 2015 to 2018, despite compensation limits being raised by 20% in January 2016. So my advice for employers who are concerned about higher premiums is for them to strengthen their risk management processes and prevent accidents. This will help them achieve savings in premiums. So once again, I thank members for their support of this bill. Your speeches reflect the views and concerns of employees and employers, and underscore the importance of maintaining a fine balance between additional protection and high business costs. Your suggestions will also help refine our implementation of the new WICA. I also thank the many groups that we have consulted, the unions, the employers, the insurers, NGOs, who have helped to shape the new WICA. To conclude, the age-old adage, prevention is better than cure, is particularly apt for today's amendments. I hope all stakeholders will continue to give us your full support as we strive towards being amongst the best in the world in workplace safety and health performance by 2028. With your permission, sir, I beg to move.
Mr. Pritam Singh.
Thank you, Speaker. I have 4 clarifications for the Minister of State. The first pertains to his remarks that this is something new that the work, or this illusion that this is a subject that the Workers' Party has suddenly developed some sort of interest in. All the parliamentary questions on, or most of the questions that were filed by members on work injury compensation for this term of government. I am not going to make the argument that the MPs who didn't file any questions have no interest in WICA.
Sure.
Having said that, I think Minister of State also said that the Workers' Party MPs, and correct me if I'm wrong, did not ask any question on it. I believe in 2017 there was a question filed, and I beg not filed, sorry, a question filed by members, and Ms. Hill-William had supplementary questions for the Minister. So that's just for the record. My first query pertains to R's case. I believe in Minister of State's reply, MOS said that it was rejected because it was out of time. But in the letter that was sent to R, the Commissioner of Labour stated that, and I'll read out the paragraph, it's a short one. We understand that you met the accident before you reached the training venue, That's the first reason. And the second is you did not make a compensation claim under WICA within 1 year from the date of the accident. So my question is, the first reason, it is settled law that if you are injured on your way to work from your workplace, that you can claim under WICA. So I am not sure why that statement was made to R. I suggested in my speech that it could be because of the way R framed his claim in the first instance to MOM. So can Minister of State just confirm that? The third issue is a question I asked in my speech, which was to give the House a sense of the numbers of all successful WICA claims by foreign and local workers over the last 5 years. I don't believe MOS answered that question. And the breakdown of workers who chose a common law remedy, private compensation, and those who did not proceed with their claims respectively. I think those numbers were not provided. The final query I have, which was also in my speech, was about whether MOM follows up with private compensations, whether MOM inquires with employers, whether MOM takes a proactive view as to whether that compensation is fair vis-à-vis WICA. Thank you.
So on the first one, on the PQs, yes, we tracked by PQs filed. So when I mentioned that there were no PQs filed, but to me, I think what's more important is that, we're all here, like I said, you're never too late to start. Second one, on R's case, really, there were two triggers, I suppose. One was, it was after more than 1 year. Second one, if you notice, after we admitted the case, we agreed that it was indeed one that WICA can cover, or WICA should cover. So in my earlier speech, I did mention that both employer and employee didn't think it was a WICA case, or it was a work-related case. So therefore, as a result, I don't think anyone thought, both whether the employer or the worker, none of them felt it was a work-related injury. So that was why it was not picked up to begin with, and why MOM rejected in the first place was that it was beyond first year. So upon appeal, we reviewed it, as I said, and we took into consideration. So after the case was admitted, right, then we were able to look deeper into the case and interview both employer and employee to understand more why was it that way. So at the end of the day, I think employees still got the case done as though it was treated by WICA. On the stats that was required, I don't think this is the right platform to provide that. I think it's better that a member files a PQ to get the stats. We have it, but I think we've got to prepare it for you in the way you've asked for it. And the last question was about...
It was about whether MOM tracks private settlements, okay, and whether they are fair for the worker.
So under the old WICA, we did not track private settlements, but moving forward, as I mentioned in my speech earlier, insurers have to report back, what are the outcomes of the cases they handle. So therefore, it will be better it will be more meaningful for us to use the database moving forward with the new WICA.
Zaqy Mohamad.
Thank you, Speaker. Just a quick follow-up again on the first point about R's case. So I understand the employer and the worker both did not believe that this was a legitimate claim under WICA. My point is the Commissioner of Labour also felt that way at the first instance. And my concern is the law is quite settled on this issue, and it is surprising that at the first instance it wasn't picked up at the MOM level. Why not?
Well, I think, like I said, there were two trigger points. First was, I suppose, beyond 1 year, the case wasn't admitted to begin with. So therefore, at that point in time, it was not possible to determine the facts of the case and to determine whether truly or not the accounts were valid and the views were valid. And it was only after the fact, when MOM had spoken to both employer and employee, were they able to establish that both of them did not think it was a work injury case. So it would not have been practical to just assume at face value until you go deeper into investigations, and of which, after investigations, after we admitted the appeal, we understood the case better, and therefore we admitted the case and awarded it accordingly. So I think in this case, the employee had also made the application 2 years after the incident, after leaving the firm. So therefore, at face value, it had breached your one-year liability by the employer. So to that extent, it was rejected upfront. But certainly after appeals, and this is what we do on appeal, we review the case, we investigate deeper, and therefore, upon investigation, we find that both of them didn't think it was, but after clarification, we took the case in.
Mr. Pritam Singh.
Just the last point, Mr. Speaker, I don't want to belabor the point. I think, MOS, the point I'm making is, this is a worker who has received a letter from MOM. If he hadn't gone for an additional recourse, seen his MP, he could have well said, look, MOM has rejected me as being out of time. Number two, they're telling me that I cannot claim because it's not claimable under WICA since I wasn't injured in the workplace, confirming his own state of mind that actually this is not an injury he can claim for. So what I'm saying is, if you put yourself in the shoes of the worker, you would realize that actually the answer MOM gave was wrong. Not the 1-year time bar, but the point about it not being a claimable injury. I think that's the issue which I'm a bit concerned about.
I don't have the letter with me. I'm sure you have it. Okay. But I think, like I said, there were two triggers. You already breached the 1-year time bar, and therefore the case is not admissible by current laws. But moving forward, under the new laws, we will be able to accept these claims a lot more readily, and therefore make the appeals a lot clearer. So I think hopefully in future we have better visibility on such appeals, and the process will facilitate it.
Zainal Sapari.
MOM will define a core set of insurance terms and conditions to prevent unfair exclusion. Since we are encouraging older workers to remain employable, will MOM ensure that the insurance company will provide coverage for all workers regardless of age, as long as they are manual or non-manual employees earning up to 2,600? Because I think there should be no exclusion clauses, especially in fine print, to deny any age group because it will affect their employability. Can I have that assurance all age group will be covered? Thank you.
Well, we have not reached the part where we've defined the terms for these insurance, but certainly we will study it and take it on board, take your suggestions on board.
Associate Professor Walter Teixeira.
Thank you, Mr. Speaker. This is on self-employed persons. MOF, I understand, I agree with you, the problem is service buyers lack the economy of scale to provide WIC coverage. But government is a large service buyer, so could government consider leading the way when buying services from SEPs to provide WIC equivalent coverage, much as you are already going to be doing for contribute as you earn in the future?
The relationship, as I mentioned, between SEPs and employers are very different. It says that employers set the conditions at which you work, and therefore, when you deal with WICA in this case, there's a lot more certainty in the environments that you're dealing with. In SEPs, as I mentioned, the SEP serves multiple buyers, not just the government, but someone else. So it's difficult to manage in that sense. But having said that, we will continue to encourage them to undertake both personal accident insurance as well as PML. I think that's the logical thing to do. And perhaps that will be priced in, hopefully, as how they charge and how they charge for the service. So we have seen, as I mentioned, the major players coming on board, and we will encourage to do so. We will encourage others to do so and continue the effort. Thank you.
Cynthia Ong.
Thank you, Mr. Speaker. MOS, I have two clarifications. The first one is on the code of practice or code of conduct, depending on how we want to call it, for the insurance companies that I mentioned in the speech. And I'm wondering, you had assured us that you will make sure that the insurers would treat each claim fairly in a timely manner. Can you share with us how you would do that? Because these are private companies. The second clarification I have, I'm absolutely delighted that you are confirming that workers are entitled for claims for mental illness resulting from work injury or at work. And you cited that there were three claims on psychological illness in the period that you cited. I shared that there was 60% of migrant workers that are predicted to have serious mental illness. So that disconnect with the number of claims that has been made, the 3 cases versus the 60%, I wonder if that's a case of clearly, both the employers and the employees, especially the employees, are not aware that they can actually make the claim. And this comes from my own personal interaction with 2 Bangladeshi workers whom I supported because they were under such extreme distress and not knowing that they can actually claim for this. Thank you.
So I'll answer the second one first. The mental illness one, I have to stress again that it has to be linked to an accident. Okay? So without that link, it's not possible to cover it under this Act. So this Act is really about accidents, and in an accident case where you have PTSD, for example, that would be something that we could cover, but you have to show that cause has been, as I said, diagnosed by a doctor. You have to show that link to an accident. Then I think then you can claim for it. As for insurers, the one thing that's different with the new WICA and the old WICA is that we are licensing the insurers. So to a certain sense, you can't sell WICA insurance. If you want to get into this business, you have to abide by the regulations. So that's the ultimate, almost I would say, assurance you can give employers in terms of the terms that the WICA insurers set. Right? There cannot be certain exclusions. There are certain terms that we need them to cover, and these will be covered. And at the same time, the database, for the insurers as well, there's assurance that employees do not under-insure. So the whole scheme of things work by providing more transparency for both the employer, the insurer, as well as the worker. So I think to a certain sense, there's that assurance that's being provided to create a different ecosystem that's based on transparency, greater transparency.
Cynthia Ong.
Thank you, Ms. So you're saying that mental illness resulting from a work injury is covered. And is that explicitly stated so that employees are aware, and also the NGOs and the medical institutions helping?
I said work accident, an injury resulting from an accident. So it has to be a mental health condition such as PTSD resulting from an accident.
Yeah, but is it explicitly stated? Or is that implied?
It's in there.
Okay.
You can. It has been covered.
Mr. Loh Jia Kiang.
Can SMS give an example of mental illness as a result of work accident that is claimable under WICA?
So as I mentioned to the mentioned earlier member, Loh Jia Kiang, one example is PTSD. So we've done 3, and all 3 were PTSD related. So they suffered post-traumatic stress disorder, post-stress PTSD, post-trauma stress disorder. Yes, PTSD, post-trauma stress disorder, after an accident that they faced, and therefore, apart from just physical injury, they also had mental injury as a result. Yes.
Question is that the bill be now read a second time. As many as of the opinions say aye. The contrary say no. I think the ayes have it. The ayes have it.
Work Injury Compensation Bill.
Committee stage, what day?
Now, sir, I beg to move that Parliament be immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee of the bill. Committee on the bill. As many as of the opinions say aye. To the contrary, say no. I think the ayes have it. The ayes have it. Question is that clauses 1 to 84 stand part of the bill. As many as of that opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. The first to fourth schedules, the question is that the first to fourth schedules stand part of the bill. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. Bill to be reported. Minister for Manpower.
Mr. Speaker, I beg to report that the bill has been considered in committee and agreed to without amendment.
Third reading, what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it.
Work Injury Compensation Bill.